Morning. Welcome to the e-Discovery Zone, live from the TechLaw Solutions booth at Legal Tech New York. We're on day one. I'm Tom O'Connor, the director of the Gulf Coast Legal Technology Center in New Orleans, along with my partner in crime, Browning Marean of DLA Piper from the San Diego office.
Indeed, and we're blessed to have Mark Sidoti with us from Gibbons.
Yes.
Well, Mark, just introduce yourself very briefly. What mischief do you do during daylight hours? Remember, we are trained in cross-examination.
Indeed, I'm aware. I am the chair of Gibbons e-Discovery Task Force. Gibbons is a regional law firm, about 250 attorneys. We've had an e-discovery task force of about 25 attorneys for the last 8 or 9 years. And I spend lots of time working on e-discovery issues throughout the firm. We're a litigation-heavy firm, so we have lots of litigation to deal with. And, of course, a lot of e-discovery issues. I'm also chair of DRI's e-discovery committee.
Oh.
So,
well, it's a great organization. Keeps you busy.
Indeed.
When we talk about e-discovery, I am struck by the critical nature of the litigation hold, and trying to get that in place and doing it effectively. Have you wrestled with that? Have you found solutions? What do you do?
Absolutely. I mean, I think that all you have to do is look at the sanctions opinions, and even over the years, to know that litigation hold is what gives rise to the vast majority of sanctions opinions and sanctions out of the courts. And it's a very, very difficult issue, which I think is only getting harder at this point. There are a number of decisions like the Pippins case that came out recently in the Southern District, which are trying to swing the pendulum, I think, in the wrong direction in terms of the whole proportionality analysis that goes with litigation hold. Where do you draw the line particularly in large matters like class action cases or collective action cases where you're dealing with potentially thousands of parties to the case? And where do you draw the line in terms of what you're asking a defendant to do in terms of preservation? Very difficult. We do mostly defense work, so I look at it from a defense perspective. But we have a hard time trying to tell clients, you can stop here, and you really don't have to go further. So, in my mind, the solution still is the cooperation aspect of dealing with your adverse counsel, because if you can work this out on paper in some sort of Rule 16 order ahead of time, I think you have obviously the protection of the court's imprimatur on how you're going to do this, and that really goes a long way, obviously.
Well, in terms of training, I was telling Tom that I was recently giving a presentation and asked a group of some 35 lawyers how many of them would write a written litigation hold to their client when the client says they want to go sue somebody. And I was, quite frankly, appalled that of those 35 attorneys, not a single hand went up.
Right.
And so it's clear to me that we still have a lot of missionary work to do. Here in New York, are you finding it a little bit more something that's a routine practice, or?
A little bit, and you know why, of course, is we have the pleasure of having all of Judge Schindler's opinions out of New York and the other fine judges who deal with these issues, and a lot more guidance in that respect. And, of course, guidance is a good thing, but it also leads to some degree of controversy. And one issue, of course, is written litigation hold. And Judge Schindler was fairly clear that written litigation hold is required in almost every case, if not every case. And other courts have not quite agreed with that. And if you have a varied practice where you have some bet the company type cases and you have some smaller cases, you will get questions in the smaller cases with the smaller clients. Do we need to do this? Do we need a company-wide litigation hold? Does it need to be in writing? And of course, Browning, you raised the issue of internally generated litigation hold notices when you are going to be filing a matter. And it comes up a lot in intellectual property cases.
Yes.
And of course, the Rambis decisions laid the groundwork for that. But there are many clients who are not issuing those, sort of going about their business in terms of litigation planning and not having anyone put the brakes on record destruction. That could be very dangerous. So.
Yeah, I've also been following a little bit from afar the New York State Court developments with respect to e-discovery. Can you comment on that?
Yeah, New York State has probably done more in committee, I think, than any other state without actually generating a good formal set of rules at this point. There's a very abbreviated set that applies to the commercial division, of course, and there's certainly a lot of guidance coming out of various committees in New York. But what I think a lot of New York practitioners are looking for is the adoption of formal rules especially in the state court level for state court practice, and we haven't seen that at this point. Much of the guidance mirrors what's already come out in terms of changes to the federal rules and what other states are doing. So I think it's headed in that direction, but in New York, it's like turning the Titanic to get things, new rules adopted and things going in the right direction. And it's ironic because there's so much of that going on in this state. It makes it difficult for the practitioners to sort of point out the rules and say this is the way it needs to be done. So state court is the Wild West in e-discovery in New York, and it's difficult to get a handle on that.
In terms of judicial education, my home jurisdiction is California. We're broke out there. We have e-discovery rules, and yet the judiciary has no resources really to train. What's the situation in New York, at least in your state courts?
Yeah, it's similar. It's similar. You really don't see a lot of formalized judicial education programs, certainly not in this area, which to me argues in favor, if they're not going to go that route, of having more of a formalized special master program in New York. I wish they would do in New York what they've done in Pennsylvania, in Pittsburgh, because I think that kind of program is going to introduce folks like us into the process to work with the judges and really help them out in areas where they need some guidance, I think, in a lot of occasions, especially with the very large cases. So I think that makes sense. It's a way of sort of getting that education to the courts. And a lot of it's done informally, but there really isn't a lot of formal judicial education.
Right. You mentioned the possible changes to the federal rules. That's under committee advisement right now. Any sense about what might happen? Any betting line on that here in New York?
Not that much. I'd rather bet on the Giants winning the Super Bowl because I know that's going to happen. But no, I mean, I really don't. I just don't have a sense if it's going to happen. I mean, a lot of these are, as you know, controversial. A lot of the issues about proportionality and dictating what is going to trigger a litigation hold and issues of that nature, changing the rubric of how sanctions are addressed by the courts. Those are issues that, we were in Georgetown earlier this year, or last year actually, hot topic of discussion. Folks, the judges are up there who deal with this all the time, don't really know where this is going to end up. And I don't either, because there's just lots of opinions on that. I tend to think it's going to either stay the way it is, or there's going to be some very truncated set of amendments, but not sort of the current proposal of some of the very specific wholesale amendments.
Yeah, there was some alternate proposed rules that really delved into sanctions and what the triggers were.
I don't see that happening.
Yeah. What about other trends for the coming year? I mean, we're hearing a lot of talk about predictive coding as being a player. Something you're coming across?
Yeah, absolutely. Particularly in the larger cases like the class actions and the collective actions. I think you're going to see more judges looking at this at the Rule 16 point and saying, look, we can't go the Pippins route here. We can't have companies holding on to personnel files for 10,000 putative class members. We have to have a way of sampling, and it has to be a sophisticated way of doing it. So let me hear you on that. Hopefully judges will say that. Bring in your experts. All right, show us how it's done. Convince me that it's going to work in this case, that you can educate the system, the computer, to locate the relevant records, and we'll try that route, because I just don't think there's any other option with all the proportionality issues going on.
Right. Yeah. Well, I'm just wondering if there's anything special you were looking for here at the show. It must be a real advantage being in New York that you can just come over.
I'm here, so I can pop in and out and see old friends and then sort of see what's new. So I'll be in and out with some frequency, but it's good to be here and good to be here with you guys.
Well, thank you so much for coming.
Thanks for your time.
Great to see you, Mark.
Yes,
our special guest was Mark Sidoti, and we'll be signing off now from the e-Discovery Zone. Thank you.